Good morning, all. This application hearing is in the matter of CFI 007-2026 and is being held by way of video conferencing before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Amarilla Legal Consultants. Lead counsel is Mr. Christopher Gunson. The defendants are represented by Pinsent Masons, and lead counsel is Mr. Ravi Jackson. Thank you, Your Honour.
Yes, well, good morning again. Mr. Jackson, can I've been speaking to Mr. Gunson about the matter that's before us. Can I confirm that you're here today to press your application being 007-2026 number 3, your application to strike out parts of the claims?
Yes, that's correct, Your Honour.
All right, good. All right, well, I invite you to make your submissions, Mr. Jackson.
Thank you, Your Honour. This application, as you will have seen, is made by the first defendant, Mr. Azzeh, and the third defendant, IDC, and it relates to a number of claims which are advanced against them. There are 3 sets of claims which are the subject of the application. First of all, what we've called the investment claims. Those are claims against Mr. Azzeh, principally in deceit, relating to an alleged investment by Mr. Gandhi, one of the claimants, in a payments technology venture. Secondly, there is the loan claim, and that's a claim against Mr. Azzeh in relation to a loan agreement entered into by the second defendant, PCS. And thirdly, there are the IDC claims, which are claims against IDC, which are premised on the doctrine of piercing the corporate veil. And those are essentially parasitic upon all the other claims made against Mr. Azzeh and PCS, but depend upon the claimants establishing piercing. And each of those claims, in my submission, is significant in the context of the proceedings as a whole. The investment claims and the loan claim account for a very large part of the claimant's case against Mr. Azzeh, both in terms of the scope of the claims that he faces and in terms of quantum. So just to give Your Honour a sense of that, the total amount claimed against Mr. Azzeh is around $2 million. And if I succeed in persuading you that the investment claims and the loan claims should be struck out, that number goes down to around $730,000. And that residual quantum would relate to relatively straightforward claims in contract under alleged services agreements. So, at least as regards Mr. Azzeh, it makes a very significant difference, both in terms of how the dispute is going to look like and what's claimed against him. In respect of IDC, the total amount claimed against it is again around $2 million. And since the IDC claims are the only claims made against IDC, if they're struck out, obviously it need not participate in the proceedings at all. So it makes a very great difference. Subject to Your Honour, what I propose to do is to take each of the sets of the claims in turn and to deal with them in the order I've addressed them in my skeleton. So if I can start with the investment claims first, that's going to occupy the majority of my time. I can be briefer, I think, on the loan claim and the IDC claims. Now, Your Honour is very familiar with the pleading requirements that apply in this jurisdiction, and I don't propose to repeat those orally now, but they're set out at paragraph 19 of my skeleton in any event. It goes without saying that in order to make a claim in deceit, a claimant needs to identify a number of basic elements in its pleading. Firstly, the representation, and that includes how and by whom it was made. Secondly, falsity. Thirdly, dishonesty. Fourthly, reliance. And fifthly, causation and loss. And in order for a defendant to have fair notice of the case made against it, those basic elements need to be alleged and they need to be properly particularised. My overarching submission is that the claimants have failed to do that in respect to the first 3 elements, so the representation, falsity, and dishonesty. What we say is that the claimant's pleading falls very far short on those fronts, and that renders the investment claim strikeable. Now, we have asked the claimants to provide further particulars via an RFI, and the answers we got were either to deny that there was any defect in the pleading, to say that it's a matter for evidence, or to respond with further vague and unparticularised allegations. So in short, what we say is that the claimants have had a fair opportunity to cure the defects we've identified, but have elected not to do so. And that has given rise to the strikeout application that's before Your Honour today. And I'll develop those points in more detail as I go, but in those circumstances, we say the investment claim should be struck out. And what I propose to do in terms of structure is deal with the three elements we say are defectively pleaded in turn. And that will require crunching through some of the pleadings, but I'll try and make my points first before taking Your Honour to some of the key examples of the pleadings that I rely upon. So if I can start then with the representations. The way in which the claimants have pleaded the representations suffers from two major defects. The first defect is that their pleading doesn't identify which representations are alleged to have induced Mr. Gandhi to make the investments. And in my submission, that's a significant flaw. If a given representation didn't affect whether Mr. Gandhi made the investments, then it's irrelevant to the claim in deceit. It doesn't go anywhere. Even if the representation was made, it's immaterial. So the claimants do need to spell out in their particulars which representations they say induced Mr. Gandhi to make the investments. But the particulars doesn't do that, and we can see that if we look at the pleading. Could Your Honour go please to page 17 of the bundle?
Yes.
And Your Honour should see towards the bottom of the page, paragraph 6.18.
Yes.
This is perhaps the central paragraph of the investment claims. And Your Honour can see it alleges that the investment was procured through material misrepresentations made by the first defendant, including 1, the pre-contractual fiduciary representations, and 2, assurances that a UAE corporate entity was already established and capable of issuing equity. So what Your Honour has is two categories expressly identified. So first of all, the pre-contractual fiduciary representations, and I'll come back to that. And secondly, the assurances. That itself, it's worth saying, is pretty vague. It appears to relate to the formulation of the second defendant PCS, but there's no clarity as to how these assurances were made or when they were made. But the real vice that I want to focus on for the moment is the word including. And what that means is that the representations that are being relied upon are non-exhaustive. It doesn't pin down which representations are alleged to have induced Mr. Gandhi to make the investments. Now, Your Honour may say, well, Mr. Jackson, that's an overly semantic point, and it's clear that what the claimants are relying upon is the two categories expressly identified. But in my submission, it's not overly semantic. Firstly, because even one of those categories, the assurances, is not properly particularised. But secondly, because when one reads the particulars as a whole, it's fair to say it's littered with alleged statements or representations which may or may not be relied upon by the claimants in this paragraph. So if Your Honour looks, for example, at paragraph 6.14 above, at 6.14, there are three different representations which are alleged. So that the second claimant's investment would secure him an equity stake in the UAE entity, entitle him to return of funds if the partnership was unwound, and be supported by formal documentation. So those are three entirely different representations to the ones pleaded, or at least identified, in paragraph 6.18. And it's not clear whether those are said to have induced Mr. Gandhi to make the investments. One can see the same thing if we go back a page to page 16. And if Your Honour would look at paragraph 6.9.2, there is an alleged statement there or representation that the first defendant required urgent capital for payments co-operations. Again, is that something that it is said induced Mr. Gandhi to make the investment? We don't know. It's not specified that it is. And similarly, if Your Honour would look at page 19 of the bundle.
Yes.
And at paragraph 7.6, there are further categories of representations, which are called the subsequent Fujitsu representations. And I won't go through all of the detail there, but again, this is a whole new category of representations. And it's not clear whether it said that those induced Mr. Gandhi to make the investments. It's just not alleged directly. So the representations, the material ones, are not clearly identified in the pleading. That I say is the first defect. The second defect is that even when one gets into the content of the representations, the pleading doesn't identify when and how the representations are alleged to have been made by Mr. Azzeh. As Your Honour will have seen in many cases, what one usually gets in a misrepresentation claim is something like, on X date, the defendant made the following representation by email to the claimant. Obviously, there are different ways of alleging representations, but that's a basic example. And the defendant can then admit or deny whether the representation was made. But what we have from the claimants in this case is very far removed from that. It really is, we say, very vague, both in terms of when the representations are alleged to have been made and how they're alleged to be made. And it lacks the necessary precision to enable us to properly answer the case or the court to properly try the case. And I'll show Your Honour that in the pleading. And what I'll do is focus on the two categories of representations that we looked at paragraph 6.18. So the pre-contractual Fujitsu representations and the assurances. If we could turn please to page 13 of the bundle.
13?
13, yes.
Yes.
And Your Honour can see in paragraph 5.7 towards the top.
Yes.
In the first sentence of that, that's where you find the definition of pre-contractual Fujitsu representations. And they're defined as these representations. So they're the ones above, we assume. If we then look at the paragraphs above, and can we start with paragraph 5.5, please? So that appears on page 12. So what's alleged in paragraph 5.5 is that from the outset, the first defendant made a series of representations that appear to be calculated to induce the claimant's involvement. So that is the overarching plea, that there were a series of representations from the outset. 5.5.1 then provides an example. The claimants would say, I think, an important example, but only an example, because it says chief among these were assertions that Prima, and by implication the venture to become the second defendant and subsequently the third defendant, held an exclusive agreement with Fujitsu International to commercialize its technology. So that is an example of the series of representations. Paragraph 5.6 then provides another example, that the first defendant represented that Fujitsu's biometric device achieved a false acceptance rate of under 1 in 100 million. But what we don't have here are specific dates for each representation, how it is alleged that the representations were made. And again, since it's pleaded in a non-exclusive way, essentially what we say is being done is that the claimants are hedging their bets. They're not specifically identifying which of the representations they rely upon. They're pleading examples. Now, we asked for further details on these paragraphs in our RFI. And Your Honour can see that if we go to page 35 of the bundle, please.
Yes.
And Your Honour can see paragraph 5.5 is dealt with in request 1. And there are a number of requests there. Request 1 sub 2 related to the jurisdictional challenge, which has rather fallen away. But in terms of the other requests, if Your Honour looks at 1.1, we ask for the date on which Mr. Azzeh is alleged to have made the representation in 5.5.1. 1.3, whether it's alleged that he made it orally or in writing. 1.4, the relevant words of document by which he's alleged to have made the representation. And 1.5, we ask them essentially to pin their colours to the mast and tell us whether they intended to allege any representations beyond those contained in 5.5.1 and 5.5.2. And we also have very similar particulars in relation to paragraph 5.6. Your Honour can see that at request 2, which runs over the page. And these are, in my submission, reasonable questions for basic details, but the response we got did not provide any proper clarity. If we could look at that, Your Honour will find a response at page 49 of the bundle.
Yes.
And I'm afraid one has to remember what was requested in the first instance because it doesn't repeat it, but hopefully it's clear to Your Honour.
Yes.
If we look at request or response 1.1 relates to timing. So we'd asked for the date on which the representations are alleged to have been made. And the response we got was that, well, they were made orally in pre-contractual discussions since August 2022 in respect to the first claimant, and since July 2022 in respect to the second claimant. And we understand that to be saying that somewhere between July, August 2022 and October 2023, because that's the first date on which the claimants say they entered into contracts with the first defendant or the second defendant. But the question then is, well, which discussions during that period?
Well, the date, why do you assume that is the relevant date, the date they entered into the contracts or the date on which the transfers were made, or both, or what?
So the claimant's pleaded case is that the first contract that was entered into was entered into in October 2023.
Yeah.
So
but what is the claimant's case about the loss that it suffered that was caused by these representations?
So I can show you on a...
Wasn't it the transfer of the funds, the 800,000?
Yes, exactly so.
So wouldn't the date of those transfers be the most relevant date, in that I assume for the transfers to have been induced by the representations would have to have occurred before the transfers?
Well, that's correct, Your Honour, but certainly from the documentation we have, the transfers are over quite a significant period of time. There's a debate and a dispute as to whether those transfers were actually made by or on behalf of Mr. Gandhi, but leaving that aside, it's quite a long period of time. They range, I think, until 2024 at least. Okay. So, and of course, when one makes a representation, let's assume the claimant's case is proved right, there may well be a delay between the making of the representation and the date on which the transfer is made.
Yes.
So one has to look at one has to go back to the RFI response, and what's being said there is that they were made orally in several pre-contractual discussions. So
you're given the starting date, but not the finishing date.
Well, yes. I mean, we're given something of a finishing date in the sense that pre-contractual, we can sort of work out where that sits by reference to the contracts. But the real problem is, well, when during that period? Yeah, we're talking about a period of over a year in which we have to root through the documents, the evidence, and try and understand for ourselves, try and guess for ourselves when the claimants say these representations were made. And that's simply not the way misrepresentation cases are pleaded in this jurisdiction. One has to identify the date on which, at least with some reasonable specificity, the date on which the representations are alleged to have been made and how they're alleged to have been made.
It may be a matter of degree, may it not? For example, a claimant may say that they were made in a series of discussions within a certain period, and I can't identify the specific dates.
I accept that, Your Honour. I accept that it is a matter of degree. What I would say is that, first of all, these are matters that we say are within the claimant's knowledge. They say these representations were made to them. They should be able to identify with reasonable precision when they say they're made, how they say they're made. Secondly, it is a matter of degree, but in respect to what we've got in the claimant's pleading, I say it falls well foul of the line. Because one can test it this way. If one imagines what we would have to do to respond to this, I mean, how is my client supposed to plead to this? He pleads that, well, he would first have to investigate the entire time period, which we assume is well over a year. Could actually be different, but let's assume that. He has to investigate that time period and then guess at any discussion that he had during that period with the claimants as to whether it's the claimant's case that the representation was made during that discussion.
I would have thought he might start by asking whether he ever made the representations.
Well, that's fair, Your Honour, and that may well be the first question, but there were numerous discussions going on with the claimants.
Yeah.
Those aren't in evidence, but for my part, I've seen some of the documents, and in order for the first defendant's legal team to properly investigate that and plead it, we need to know what the target is that we're aiming at. Now, if what the claimants have pleaded is, during a specific month or during a specific week, there were a number of discussions in which the following representations were made, that would be one thing. But the lack of precision here is really quite extreme. And it goes beyond the oral representations, Your Honour. If we could look at what they then say about the written representations. So you can see in Roman numeral 2, under 1.1, it said that the representations were made in writing and documentation, including, so again, this is being pleaded in a non-exhaustive way, the presentations exhibited to the particulars, as well as scheme implementation documents and other written correspondence. Now, we can, of course, read the documents that are exhibited to the particulars. What I can't do is identify any other written correspondence. If there is a specific document in which it is alleged that a representation has been made, the claimants should be able to identify that, but they don't do so. And again, all of this is, as I say, essentially bet hedging, because all of it's being pleaded in a non-exhaustive way. But the other point on the documents is there's no identification of when those documents were sent to the claimants, how they were communicated to them. So again, there's not any specificity as to the context in which the representations are alleged to have been made. And what it would require in respect to the written representations is essentially for us to leaf through documents to identify where we think a representation is being said to have been made, and indeed to guess what further documents might be relied upon by the claimants. And again, I say that that's simply not the way misrepresentation claims are pleaded in this court. If we could then look at response 1.5. So I showed you on a request 1.5 earlier, and that was where we invited the claimants to confirm whether they relied upon any other representations other than the two pre-contractual Fujitsu representations that are expressly identified. We asked them to tell us that, but as Your Honour can see, there's no confirmation of that. All they say is, see the responses above, and then they say the representations were continuous, and that paragraph 5.2 of the particulars refers to written examples. So they're not committing to a position. They're just saying, see the responses above, and we've set out some examples in the particulars. Actually, that paragraph of the particulars doesn't set out any examples in any event. But that in my submission is not a satisfactory response to us asking them to identify whether there are any further representations that they allege, which is inherent in the case that they pleaded. If we can then look at the other category of representations, the other main category, which is, if I can just remind Your Honour of that, we could go to page 17 of the bundle, please. And we looked at this earlier on, it's paragraph 6.18 of the particulars.
Yes.
So these are the assurances that a UAE corporate entity was already established and capable of issuing equity. So we asked for details of that. We asked for the date on which Mr. Azzeh was alleged to have given the assurances, whether he's alleged to have given them orally or in writing, and how they are communicated. And I won't go to it, but Your Honour can see that in our RFI, paragraph 15, page 42. Those were, in my submission, again, basic questions. And again, the response we got was simply inadequate. We could look at the response at page 51 of the bundle, please.
Yes, what number?
And it's response 15.
Yes.
So Your Honour can see what's said in 15.1. Firstly, is that the claimants do not allege that Mr. Azzeh represented that a UAE entity was already established. Instead, they allege something else. But that's simply not how it's pleaded in the particulars. It's pleaded that the assurance was a UAE entity was already established. So we are confused by that. Secondly, they don't identify any date on which the assurances were allegedly given. Instead, if Your Honour looks at subparagraph 2 and 3 of 15, it said the representations were continuous. And thirdly, if Your Honour looks at subparagraph 3, it said that they were made orally, in person, and video conference meetings. Now, as Your Honour said, there's a spectrum, but in my submission, simply saying, well, they were made orally, in person, and video conference meetings is well outside the range of reasonable precision that one would expect in a claim for misrepresentation. I mean, it doesn't even tie it down by year. So there's no way in which we can properly respond to this, or the case can properly be tried on the basis of an allegation like that. Now, I don't propose to take Your Honour through all of the other alleged representations in the same level of detail, but we say it's the same story. There's a real lack of clarity in the particulars as to when and how these representations are alleged to have been made. We asked for proper clarity in the RFI, and the claimants didn't provide it. And what we get are these very vague and non-exhaustive allegations. And just for Your Honour's note, I won't take you to them now, but you can see that from response 13.2 on page 51, 14.2 on page 51, and response 23 on page 52. So there's other examples of representations which we say unparticularized. We asked for further detail. It wasn't provided. And the position we in the court are left in my submission is that this case can't properly be prepared for trial or indeed tried, at least in the manner it's pleaded. And Your Honour can test that by considering how things will go when we get to disclosure and witness statements. As Your Honour knows, disclosure in these courts is intended to be a very focused and efficient exercise through the use of essentially Redfern schedules. Now, if we were to have disclosure on the basis of the claimant's current pleading, it's very likely in my submission to become an unwieldy exercise. because the representations haven't been properly identified, what's very likely to happen, almost certainly to happen, is that we will get overly broad requests which aren't tied to specific material facts and range across significant periods of time. Now, that isn't how disclosure works in these courts, and in my submission, it's a recipe for satellite disputes on disclosure. And when we get to witness statements, it will not be possible for Mr. Azzeh to properly focus his evidence on the relevant representations, because he simply won't have any clarity on when and how they are alleged to have been made. He'll have to try and cover absolutely everything that he discussed. Moreover, when we get to trial, my client won't have any clarity on the case that's being advanced. Instead, what he'll have to do is essentially play whack-a-mole and respond to the case as it's developed by the claimants during the trial. In my submission, that wouldn't be fair. He's entitled to proper notice of the case that's being run, and that simply hasn't been provided.
It might be, Mr. Gunson may say it's not the case, but it might be that what the claimant is doing is keeping their pleas very wide and broad, and then going to seek disclosure from you on a very wide and broad basis, and then seek to firm up its particulars or details of its representations after getting disclosure. That's a not uncommon sort of a scenario.
Well, it may be not uncommon as a litigation tactic, Your Honour.
Yes.
But it's not, and I'm sure Your Honour has experienced that, but not the procedure in this court.
Yes.
It requires you to set out the basic material facts upon which you rely. And in respect of representations, the law is very clear. The RDC expressly says you need to set out details of the representations. That simply hasn't been done. But if I can move then to falsity, which is the second element that I say isn't properly pleaded. Now, to be fair to Mr. Gunson, there are a limited number of instances in which the claimants do plead particulars of falsity in the particulars. So I'm not telling Your Honour that it is not pleaded at all. But what I do say is that for the vast majority of the representations, falsity is either not pleaded at all or is just not particularised. Just to show Your Honour a few examples of that, if we could go to paragraph 5.5.1 of the POC, that's at page 12 of the bundle.
Yes.
So Your Honour will see there, we looked at this earlier, but it's the alleged representation relating to the exclusive agreement. But there is no allegation of falsity there or particulars provided. Now, Your Honour may say, well, the case must be that you didn't have an exclusive agreement with Fujitsu. But if that is the case, it should be spelt out. And it's simply not. And there are more nuanced examples than that. If we could look at page 16 of the bundle, please. And at paragraph 6.9.2.
Yes.
So this is the representation we looked at earlier relating to urgent capital for the payments co-operations. Again, there's no allegation of falsity or particulars there. And if we look at 6.14 over the page, again, we looked at this earlier, it's the collection of 3 representations relating to essentially the second claimant's entitlements. Again, there's no allegation of falsity in relation to that or no particulars of falsity provided. So in respect of what I say is a basic element of claim and deceit, the claimants simply haven't provided the necessary detail to allege falsity. Now, Your Honour may say, well, that's a good point for you, Mr. Jackson, at trial, because you can say that the claim simply can't succeed in circumstances where they haven't pleaded falsity. But my submission is that, well, that's a reason why the claim is defective now, and we shouldn't have to go through the expense of preparing for trial on a case very unclear and then having to fight it. So for the same reasons I gave earlier, we say the pleas of falsity are deficient, and that renders the investment claim strikable. Can I then move on to the third element, dishonesty? This is an issue on which we say the lack of particularization is very surprising indeed. And I can deal with it relatively shortly, but that shouldn't underplay how important a point we say it is. Now, Your Honour will be very familiar with the principle that a defendant is entitled not only to notice that an allegation of dishonesty is made, but also to particulars supporting that allegation. And that's well established in various authorities. In my skeleton at paragraph 19, I cited the SPM decision of Justice Lord Angus Glennie in this jurisdiction, and the Three Rivers decision in England, which SPM follows. And I appreciate Your Honour being familiar with these principles. I could just emphasise one point, which is at paragraph 19.2 of my skeleton. That's at page 287 of the bundle.
Yes.
I quoted there paragraph 186 of Three Rivers. The part I want to focus on is towards the middle of that quote, which is in bold. The defendant is entitled to know the case he has to meet. But since dishonesty is usually a matter of inference from primary facts, this involves knowing not only that he is alleged to have acted dishonestly, but also the primary facts which will be relied on at trial to justify the inference. And there's a similar point made by Lord Hope, which I've quoted at subparagraph 3. And those comments, those dicta, in my submission map directly onto the present case. Because what the claimants have done is plead a bare allegation of dishonesty, shorn of any particulars. So they allege that Mr. Azzeh was dishonest in making the representations, but they don't identify the primary facts from which that inference, and it must be an inference, is being drawn. And to see that, we need to go back to paragraph 6.18 of the POC, which I started with. So that's at page 17 of the bundle, Your Honour.
Yeah, which paragraph?
6.18, and it's actually 6.18.1, where Your Honour will find the allegation of dishonesty. So it said there, each of these statements was false, known or reckless as to truth, and made to induce the second claimant to transfer funds. And then all that one finds one would expect to find particulars in the subparagraphs, but actually one doesn't find that. So subparagraph A refers to it being an established principle of DIFC contract law.
So they're just legal submissions made?
They're just legal submissions, exactly. Your Honour has the point. So no primary facts pleaded in support of the inference of dishonesty. Now again, we ask the claimants for further details on this. We ask them to identify the facts and matters relied upon in support of the dishonesty allegation. I can show Your Honour that in our RFI if we go to page 43 of the bundle.
Yes.
And at subparagraph 5 at the top, Your Honour can see we ask for all facts and matters relied upon in support of the allegations that each of these statements was false, known, or reckless as to truth, etc. And the response we got was, in my submission, remarkable. It was to say, well, this is a matter for evidence. Your Honour can see that at page 51 of the bundle. And it's response 15 sub 5. About 2/3 of the way down, where the claimants say this is a request for evidence, not clarification of pleaded case. And that point is repeated in the claimant's evidence, even in response to the application. I don't need to take Your Honour to it, but that's Mr. Gunson's third witness statement, paragraph 31B, page 129 of the bundle. In my submission, it's a very surprising position being taken. It's clearly wrong as a matter of law to advance such a serious allegation the claimants needed to identify the primary facts from which dishonesty is being inferred. They haven't done so, and essentially, they said we can defer all of this to evidence. That's simply not the way this court deals with allegations of dishonesty. So for that reason, too, we say the investment claims are fundamentally defective and should be struck out. Now, if I could sweep up a few brief points made by the claimants in their evidence and skeleton. There are really three main arguments that they raise in opposition to the application, at least as far as the investment claims are concerned. First of all, they say we're seeking what they call disclosure level particulars. And as I've attempted to show, Your Honour, we say that's simply not correct. We're seeking identification, or were seeking identification of basic material facts. Those haven't been provided. And we say, in those circumstances, the claims are defective, the claimants had every opportunity, and the claim should be struck out. Secondly, claimants say the information is all within our possession. In my submission, that's clearly not correct. The representations and the basis on which falsity is alleged should be within the claimant's possession. And the same for the facts from which they infer dishonesty. Those are all matters which a claimant in a fraud claim, in a dishonesty claim, is expected to identify and plead. That's what the RDC provides, that's what the case law provides. And that the claimant should be well within, it should be well within their ability, if they have a case, to tell us what that case is, but they simply haven't done so. The third point they make is that they say, well, this was a continuous relationship over time. It's between commercial parties and involved essentially numerous dealings. But as Your Honour will know, most commercial cases in this court involve quite extensive commercial dealings. Many cases involving alleged representations do so. That is not a reason not to identify with precision the representations that you rely upon. Now, that seems to have morphed somewhat in my learned friend's skeleton. What he appears to now say is, well, as a matter of law, we say these were continuing representations. So rather than them being factually repeated, they are made at the outset, but then they're continuing as a matter of law. Well, in my submission, it's not the way the case is actually pleaded, as I've shown, Your Honour. It's not the way the RFI response deals with it. But in any event, it doesn't help the claimants, because even if it were alleged that these were continuing representations as a matter of law, one still needs to identify the first instance on which the representation was made. And the particulars don't do so with sufficient clarity, nor does the RFI response. So for those reasons, we say the investment claims should be struck out. Can I move on then to the loan claim? And as I said, I can be more brief on this. The loan claim really is a very short point. The claim as pleaded against Mr. Azzeh is that he is liable to the claimants in relation to sums owed by PCS, the second defendant, under the loan agreement. Now, we say that claim makes no sense as a matter of law with respect. Mr. Azzeh was not a party, has never been a party to the loan agreement, so he can't be liable under it. Contractual privity, we say, is a short and complete answer to the loan claim. In their evidence opposing the application, the claimants don't dispute that Mr. Azzeh was never a party to the loan agreement. But instead, they rather move the goalposts. They say, well, we've misunderstood their pleaded case. The claimants say their pleaded case is that Mr. Gandhi was induced by misrepresentations to give a guarantee in respect of the loan. Now, that is a very different type of claim. And it's simply wrong to say that it has been pleaded by the claimants. There is no pleaded case, Your Honour will find, that Mr. Gandhi was induced by misrepresentations to give a guarantee in respect of the loan. And I do need to show Your Honour the evidence and the pleadings on this briefly. We could look at Mr. Gunson's third witness statement first, please. Page 132 of the bundle.
Yes. What paragraph?
Paragraph 49. So there, Your Honour will see they don't dispute that Mr. Azzeh was not a party. That's in the last sentence. Then at 52, it said the claimant's case is that but for the first defendant's representations and inducements and certain conduct, the second claimant would not have agreed to provide the personal guarantee or assume exposure under the loan arrangements. And then if Your Honour goes over the page to paragraph 62, that's at the bottom of the page.
Yes.
It suggested that the defendants are, quote, ignoring the broader pleaded factual and legal basis upon which liability is alleged to arise. So Your Honour is being told in no uncertain terms that, well, the pleaded case is different. But there's no part of the pleading which is actually referred to in the evidence in Mr. Gunson's statement in support of the position he expresses here. And no such part exists when one actually looks at what the pleaded case is. So if we could go to the particulars at starts at page 23 of the bundle. And it's paragraph 8, which deals with the loan.
Yes.
At paragraph 8.1, it's pleaded the second defendant entered into the loan agreement. At 8.2, it's pleaded that the second claimant, that's Mr. Gandhi being referred to, provided a guarantee securing the second defendant's obligations. But there's no allegation there that he was induced to do so because of representations by the first defendant. All that's pleaded is that he entered into the guarantee. Then at paragraph 8.5, it's alleged that there was persistent non-payment essentially by the second defendant, which led the lender to call upon the second claimant under the personal guarantee. And then at paragraphs 8.6 to 8.8, the basis on which the loan claim is made is developed. And what's alleged is that Mr. Gandhi has paid some sums under the guarantee, and as a result, he's entitled to pursue the second defendant for those sums via subrogation. And it's also alleged that the lender has assigned to him, under an assignment agreement, the right to pursue contractual interest. So all of that goes to the claim that he makes against the second defendant. None of it goes to Mr. Azzeh, and none of it says that Mr. Azzeh made representations which caused Mr. Gandhi to enter into the guarantee. And one can see that from the final paragraph of section 8. If Your Honour goes over the page and looks at paragraph 8.9, what's said there is that the defendants remain jointly and severally liable for repayment of the loan amount and all associated contractual sums, and the claimants seek recovery of these amounts pursuant to the loan, the personal guarantee, the subrogated rights, and the assigned rights. So that is expressly saying that the basis on which we are pursuing recovery is under the contractual documents, subrogation, and by the assignment of the rights. It's not saying that we are seeking damages on the basis of deceit or misrepresentation. So what is suggested in the claimant's evidence is simply wrong, and it is, in my submission, surprising that the evidence seeks to characterise the claimant's pleaded case in this way. But in any event, the simple point is that the only loan claim that has been pleaded can't succeed because, as both parties accept, Mr. Azzeh was not a party to the loan. And that part of the pleaded case should therefore be struck out. Finally, then, can I deal with the IDC claims? Now, my submissions on this are set out at paragraphs 47 to 56 of my skeleton. It's at page 294 of the bundle.
Sorry, which paragraphs?
Paragraphs 47 to 56.
Yes, okay.
And I make a number of points on the IDC claims, including that they're not properly particularised, and that any allegation of piercing could not apply in respect of Mr. Azzeh. But the point I want to focus on really is my primary point, which is that I say the doctrine of piercing the corporate veil simply doesn't exist under DIFC law. And in those circumstances, the IDC claims simply can't succeed because all of the IDC claims are premised upon piercing. As I said at the outset, they're parasitic upon the other claims made against the first defendant and the second defendant. So if the claimants don't succeed on the piercing point, they simply can't succeed at all against IDC. And that is a short point of law. It doesn't depend on the facts. And if Your Honour is with me on it, it provides a complete answer to the claims. So I do invite...
What if I'm not?
Well, if you're not, I mean, my other points in my skeleton would still stand.
You've made other points about the adequacy of the plea of piercing the veil.
Yes, exactly. But my primary point, really what I want to focus the whole argument on, is this point of law. So the starting point in my submission is that, as Your Honour will know, DIFC law is statutory. And while the DIFC courts do take into account jurisprudence of other common law jurisdictions, what they don't do is engage in judicial legislation. And that's well established at the Court of Appeal. Your Honour will no doubt be familiar with.
Under the court's law, it's a little bit more than the law being confined to statute. As you say, the court can have regard to the common law in other jurisdictions.
Yes, it can, Your Honour, certainly. But the way in which it has regard to the law of other common law jurisdictions is in assisting the court in interpreting the DIFC statutes. So what the court doesn't do is effectively create by its judgment something akin to a provision that doesn't exist in a DIFC statute.
Well, of course, in the case top cited, the Court of Appeal said it doesn't. The court can't create new causes of action beyond the statute. So that's at one extreme. The other extreme, as you say, it's clear that the court can use common law of other jurisdictions to assist in interpreting the statute, and there may be some room in between with the application of the law. But in any event, I know your point.
Yes, and I accept that there is a spectrum. Yeah. My submission is that the doctrine of piercing is very much towards the end of the cause of action spectrum rather than the other way. And the reason I say that is because without the doctrine, the claimants do not have any cause of action against IDC. So it is if I put it like this, a radical doctrine in terms of its effect and how it allows the claimants to bring IDC into the proceedings if they're right that it exists. Now, in short, what I say, and I don't propose to take Your Honour through the TIG case, I can well see that you're familiar with it. But what I say is that the claimants, as per that case, would need to identify, in this case, a DIFC statute which has a provision in it which recognises the doctrine of piercing the corporate veil, or is at least something the court could interpret as having that effect. Well, the question then is, well, what statute do they rely upon? What is the provision which entitles them to pierce the corporate veil? And we simply don't have an answer to that. They haven't identified a statute which they say would allow for piercing the corporate veil. Both the claimant's evidence in response to the application and my learned friend's skeleton are simply silent on that point. And my skeleton, I've referred, Your Honour, to the Companies Act. That is the most obvious place one would expect to find such a provision. if there's a doctrine of piercing, one would expect it to be recognised there because it's essentially a company law point. But the company's law doesn't contain any such provision. And to the contrary, in my submission, it militates against the doctrine applying as matter of DIFC law because it recognises the concept of separate legal personality, as one would expect, but it also says that effectively any exception to that principle must be contained in the company's law. Now, if I could show Your Honour that, it's in the authorities section. It's at 865 of the bundle.
Yes.
And it's Article 9, which deals with legal personality and says a company shall have a separate legal personality from that of its shareholders. The liabilities of a company, whether arising in contract, tort, or otherwise, are the company's liabilities and not the personal liabilities of any shareholder or officer of the company, except where otherwise provided in this law. And those final words are important. Obviously, there can be exceptions to separate legal personality, but piercing isn't one of them because it's not recognised, it's not contained in any provision under the company's law. It would need to be spelt out. So for those reasons, we say the doctrine simply doesn't exist under DIFC law. Now, Your Honour might question whether that leaves something of a gap in DIFC law. But I'd make 2 points in relation to that. First of all, the same point could have been made in Hamid about the torts in that case. A defendant or claimant will often say, well, if I can't bring this cause of action, if I can't apply this doctrine, there's a lacuna in the law. But that's not the approach the Court of Appeal. The Court of Appeal made clear that's not the approach of the DIFC courts. They won't fill gaps in the law in that way. It has to be done by statute rather than judicial legislation. But secondly, and perhaps more fundamentally, even if there was a gap in DIFC law, it would be a very slight one. Even as a matter of English law, which I think is where the claimants are taking this principle from, the doctrine of piercing applies in very limited circumstances. It's where a party is deliberately frustrated pre-existing obligations it owes by interposing a company. And the English courts have made very clear that in most cases, piercing is entirely unnecessary because the claimant can rely upon a doctrine like agency. And more recently,
or insolvency provisions.
Or insolvency provisions, exactly. So one doesn't need to resort to piercing. And the cases in which piercing have actually succeeded in the English courts can be counted on one hand with some fingers to spare. So it's a very slight gap indeed. I mean, I've set this out in my skeleton at paragraphs 49 to 50.
Yes.
But even in recent years, the UK Supreme Court has doubted whether the doctrine exists at all, or is a coherent rule of law, rather than a sort of portmanteau for a number of different legal concepts. So I say that shouldn't trouble Your Honour, if Your Honour was otherwise minded to strike out the IDC claims. And for those reasons, I invite Your Honour to do so.
Yes.
Your Honour, those are my primary submissions in support of the application. The claimants have floated the idea of an amendment. I've dealt with that in my skeleton, so I might save that for replying if it's a point that Mr. raises orally.
Yes. All right. Well, thank you very much, Mr. Jackson. Mr. Gunson.
Your Honour, may it please the court? I appear for the claimants who are the respondents to this application. And I will say at the outset what this application really is by stating what it is not, which is that it is not in substance nor in proper procedure a genuine strikeout application. It is not an attempt to identify a claim that is truly hopeless or legally impossible or incapable of being tried. It is just the latest step in a pattern of maneuvers with the practical effect of delaying the proceedings, substantially increasing the costs far beyond what is necessary and postpone the point at which the defendants must finally plead to the merits. And there have been repeated itemizations of certain areas put into focus with the comments that the case cannot be understood. But I believe that it's clear the application shows that they understand the claim very well. They engage with the claims, the representations, the loan claim, the IDC claim, the documents, and the alleged consequences. The problem is not they cannot plead. The problem is that they do not want to plead. And my learned friend has taken about an hour of the court's time. I can imagine I might take about the same amount of time in my response. But before I come to the strikeout application itself, it is necessary to address the background to this claim because this application does not arise in a vacuum. And the procedural history is a very fitting introduction to what has taken place so far, and it reveals the true character of the present application. So forgive me as I run through the timeline. The particulars of claim...
By all means, Mr. Gunson, but in the end, you're going to have to come to grips with the specific submissions which Mr. Jackson has made.
Oh, Your Honor, that will be done in detail. Yes.
All right.
The particulars of claim were filed on the 2nd of February, and service was acknowledged on the 4th of March. And thereafter, the defendant's counsel requested a 6-week extension to serve their response for various reasons, which the claimants were asked to agree to. And the claimants are very reasonable, but 6 weeks is a very long delay at the beginning of a case. So the claimants offered a limited extension. The defendants did not accept that and made an application to the court for an extension of time. And the court then issued its order on the 10th of April with reasons. And in substance, the court did not grant the extension the defendants wanted and imposed a very tight timetable. And that timetable matters, so I will just briefly summarize it. If the defendants were to dispute jurisdiction, they had to do so by the 13th of April. That was only 3 days after the order. If they did not challenge jurisdiction, they had to file their defense by the 21st of April, which is 10 or 11 days after the order. But if a jurisdiction challenge was filed, then the defense deadline would be stayed pending the determination of that application. So this is a very short and clear timetable set by the court that was designed to move the case forward. And there are also 2 further parts of that order that are especially important for today. The court stated that it was...
I must say, Mr. Gunson, I've read most of this, but in the end, I'm going to have to deal with the specific submissions that Mr. Jackson has made. I can't deal with it in some broad approach to the motivation or approach of the claimants. I have to come to grips with the specific submissions they make.
Well, Your Honor, the email from the court, the subject email was jurisdiction application.
Well, I'm sorry, I thought we established at the beginning the application we're dealing with is the strikeout application, and you acknowledged that and
Yes.
said that you're able to deal with that today. So
Correct.
that's what we're dealing with, and that's all we're dealing with.
Well, Your Honor, I do believe this brief procedural history is relevant to the strikeout application and should be heard.
I have read it, so if there's something that you have to add to what's in the submissions, fine. But I don't want to take up a lot of time with things which are not in contest, which are on the record and which I've read in the submissions.
Well, then, Your Honor, I would ask, with regards to the jurisdiction application that was filed and which was then withdrawn, this was an application made to the court. Is it not something that should be dealt with by the court?
Well, it's not before me today.
Well, then I will just, I still believe it is, before addressing the strikeout application, it is proper to just address, again, in brief, the the procedural history of this matter.
Well, I suspect it's going to be quicker if I sit quietly and let you do that, but I'd ask you to do it as quickly as you can.
Okay, I will be very brief then, because again, I think it is very relevant to today's application. The first and third defendants did challenge jurisdiction. A response was then filed, and once this response was filed, it was withdrawn. Now, I can think there are only two explanations for why that jurisdiction challenge was made. One would be that the defendants did not appreciate the DIFC law position, but the other would have been just to drive up the claimant's costs, which is a well-known tactic in any litigation. And the other thing that is key is that the court set a tight timetable. The defendants have benefited from what we might call a loophole in the court's order. And I say that not as a criticism of the court, because the order was clear, but the defendants have filed an application, withdrawn it, but still benefit from the delay. So we still have today, 2 months after the court expected it, a filing of a defense, which we do not have. So I do not need the court today to make a finding about that, but I just put that forward as the approach and character of the way the defendants are approaching this case. I think it is a further reason why the strikeout application should be viewed with caution, because this application is not an isolated event. It is just the next step in the same sequence, which has the same effect, which is to delay the defense, delay disclosure, and keep the case away from the merits. And with regards to the increase in costs, the jurisdiction application was not withdrawn as required by the RDC. The RDC requires an application when requesting a court order. There's a reason for the RDC rule in this regard. An application is filed, a response is given, and the court then makes a determination. And in doing this by email, correspondence with the registry, which is typically for a case management, what has happened is that once again, both parties are going back and forth on emails in ways that increase costs. So with that, I will now turn to the strikeout application, but I do think that jurisdiction application is important and must be considered by the court. And what I would say today with regards to the true substance of the application is that there are two key questions, which is, does the particulars of claim disclose reasonable grounds for bringing the claim? And the answer is yes. And if it could benefit from additional detail, is strike out the proportionate response. And there the answer is no. And that really should be the end of the application. And the court has already considered the defendant's complaint that the particulars of claim were insufficient. That is in the order dated the 10th of April. The court stated it was satisfied. But yes, Your Honor, please go ahead.
Well, show me where in the order the court said that. This is in the April 10th
Yes, Your Honor.
order. What page is that in the bundle? I thought that was solely in relation to the jurisdiction issue. I didn't think the court gave any consideration to whether or not the particulars of claim complied with the pleading requirements under the rules.
If we look at the schedule of reasons of the court order.
Yes, what page?
So if you look at the bundle.
Yes.
Into
It's page 140.
Thank you.
Thank you.
Right. I mean, in paragraph 7,
Yes, in paragraph 7, yes.
The court is not persuaded. Well, I should begin at the beginning. The defendant served an RFI. They contend that they require that to await a response before filing a defence in any or Part 12 application. The court is not persuaded that this justifies the length of the extension sought. As a matter of procedure, a request under Part 19 does not pose an obligation to respond, absent a court order, and does not of itself suspend or extend existing deadlines. Secondly, while targeted clarification in an appropriate case can assist efficient pleading, the court cannot permit a broad RFI to be used as a mechanism to delay compliance with time limits at the start of the proceedings. And the court makes no comment, no observation there about the adequacy of the pleading.
Well, Your Honor, I would direct you to the next paragraph, item 8. And I'm pleased to read it. In the second sentence, the court says, on the material before it, the court is satisfied.
Well, we'll just start before that. The court makes no final determination on pleading's adequacy on this application.
However,
the court is satisfied the defendants are able to plead at least to jurisdiction. So that's a matter that the court was turning its mind to.
Well, Your Honor, I'd like to finish the sentence, which says that, and or to file a defense in due course on the basis of the particulars of claim as presently drafted, with any truly necessary requests for clarification to be addressed by focused RDC Part 19 applications or case management directions if required. That is the line I'm referring to.
Well, what Mr. Jackson says is they sent a Part 19 and they didn't get any adequate answers.
Well, Your Honor, then I would refer you to Part 19.1 of the RDC. I mean, first of all, let us address the RDC. There is no obligation to respond to a request for further information absent a court order. But the claimants have given that response. And RDC Part 19.1 says that a party may request to the court to give orders with regards to requests for further information, and that has not been done.
So what are you suggesting? They should now get a court order to ask to make a request for information in the terms in which they served it on you, and what, you'll give different answers or the same answers or what?
Well, Your Honor, we do not even have a defense at this point. No defense has been served.
No, they're asking for the request before the defense. Now, I don't know if that's an issue you're raising. I thought I'm not sure where you're going with that. Perhaps you should develop it.
Well, I'm pleased to return to my points. Yes. So I believe it is quite clear in paragraph 8 of the court's order that the court was satisfied that the defendants were able to plead, or file a defense on the particulars of claim as drafted. And the court also identified the proper route, which was focused Part 19 applications, or in the alternative, case management directions. So the defendants are attempting to reopen through a strikeout application an issue that the court has already dealt with in substance. The court has said the proper route is RDC Part 19 or case management directions, and they do not identify a claim that is hopeless. They do not identify a claim that is legally impossible or unintelligible. What they essentially dispute are matters that they say require more evidence and that should have been pleaded with great precision.
Mr. Jackson doesn't say that. He was very specific to say he's not asking for evidence. He's saying what he characterizes it as is particulars. You characterize it as evidence.
Well, Your Honor, the particulars of claim do attach a substantive amount of evidence that are not included in the case bundle due to the length. But the particulars of claim are, I believe, 900 pages in total length. So there is substantial evidence provided on this point.
But are you suggesting sorry, are you submitting that in relation to the matters where Mr. Jackson says the particulars do not adequately plead the necessary facts, is your submission that what they should do is trawl through the 900 pages to see if they can find them in there somewhere?
Your Honor, if the particulars of claim are insufficient in any way, we have received a request for further information. Response has been given. And without further engagement on this matter, including not responding to the claimant's own request for further information, which has been submitted and it has not been replied to now, although it has now been, I believe, close to 1 month. The approach that's been taken has been to jump to a strikeout claim, and that is not the appropriate procedural course.
Well, what I thought you were saying what they should have done was to make a request for information, or have I misunderstood you?
Well, the court has said originally on the 10th of April that the deadline for filing a defense was about 2 months ago, on the 21st of April. So we would expect, given that the jurisdiction application has been withdrawn, then the first thing to be done would be to file a defense as the court already instructed.
Yes. All right. That's what you expected, but they've done something different.
Yes, and we're doing that application today.
Yes.
And I mean, we have given an introduction to the strikeout claim itself, and there are 3 claims that are identified and are objected to. I will go through each of those now, item by item. And first is with regards to the investment claims.
All right.
Here, there is just a repeated assertion that the representations are insufficiently particularized. And, Your Honor, that submission overreaches. The claimants have pled the substance of the representations. They have pled the commercial setting. They have pled the approximate period. They have pled the persons
Wait a minute.
involved.
When you say the approximate period, and the ones that Mr. Jackson took me to, they gave a starting date. It was, I think, representations made commencing or from or something to that effect. It doesn't give a period during which they were made. It just gives a starting date.
Yes, and my learned friend also said it took place for about a year. So he also referenced to an approximate period. That's correct.
Well, your pleading doesn't say that. That's something which he was inferring from it. And I must say I drew a different inference from it. But what is it? What is the period supposed to be? Is it from those stated days in July or August through to when?
Well, it's through, I mean, the duration of the commercial relationship it is approximately 1 year. But Your Honor also said
the duration of the commercial relationship, as I understand it, the investment claims, and you obviously know the case much better than I do, but in very broad outline, the matters we're concerned with are representations that were made which induced the first claimant, to make certain investments. Now, I've either understood from the plea or assumed the investments referred to are the transfers of money referred to. Have I got it right in broad outline?
Yes, in broad outline, yes. And Your Honor also said that you envisioned that what the claimant was doing was anticipating discovery, and that is also correct. And that is the proper procedural course in due course to come to discovery.
Well, over the years, I have, like I'm sure most involved in commercial litigation, had endless arguments about whether a claimant may make a unparticularized claim and ask for discovery, or whether he's got to be more particularized so that the discovery is then confined to the particulars he's given. On the one hand, you would say it's sufficiently particularised. On the other side, they will say you're fishing for a case that you haven't got yet. Now, that's old. I'm putting it at a very high level. Those,
yeah, Your Honor, that is not a fair characterization of this case. I mean, in this case, I mean, this was not one single representation that was made in a single letter on a single date. It was a course of repeated representations and inducements over time. It concerned matters such as an exclusivity to Fujitsu, well, it's a relationship to technology, a contract, commercial viability, investment, equity, capability, and the establishment and use of the relevant corporate vehicles.
Well, take that last point. It seemed, I may have misunderstood it, but the answer you gave in the request for information was inconsistent with the plea in the particulars, in that the plea in the particulars says that there was a representation that the entity was already established. In the request for information, you said, no, that's not your case. Your case is that it will be established. So on the face of it, there's an inconsistency there, is there not?
Well, Your Honor, I believe that today is not a trial on the merits. It is I mean, if that is the case, which I would like to park at this moment, if that is the case, then I think it's very clear, then the proper course would be to, first of all, engage further with the claimants with a follow-up request for further information, and if explaining the reasons why more information is required, and or to proceed with a Part 19.1 application to the court that further information is required and a court order is required. That, I believe, is the proper procedural course.
Well, one way in which I might, there are a number of ways in which I might deal with this application. At one end would be to strike out all of the parts of the claim that Mr. Jackson wants me to strike them out. At the other end would be to dismiss his application altogether. Some of the other things I might do is to require you to give particulars or strike out parts and require you to particularise them. There's probably a range of things that can be done if I come to the view that you've not adequately particularised them. Strikeout's not the only thing, or at least strike out the claim without pre-pleading is not the only thing.
Well, Your Honor, you are stating what is, of course, the case, but you are stating that without allowing me to complete my remarks, which I think are very important to regarding the claimant's case, which is, this is a complex commercial relationship on the one hand, but today is not trial, and I am not getting into the strength of this case. I am only referring to the strikeout application, which, as I've said at the outside, it overreaches. It is not the proper procedural course, and I think it's suitable that you allow me to go through each of these.
I'm not stopping you, Mr. Gunson. I'm inviting you to do that.
Yes. So, I mean, to return to the investment claim, I mean, where a case concerns repeated conduct over a commercial relationship, a pleading may properly identify the course of conduct and the core representations that are relied upon, and that is already provided in substantial detail in the particulars of claim, and further evidence will be provided in due course, as is the proper procedure in a trial.
Well, there's a difference, isn't there, between, on the one hand, stating what the representations are and in due course providing evidence that those representations were made. There's a difference between that on the one hand, and on the other hand, pleading some representations and then at a later time producing evidence of different representations.
But correct, and that is nothing that has been pled is wrong in this regard.
No, but the complaint was not that you'd pled something wrong. The complaint was you've used the word including and chief among, which Mr. Jackson says, therefore, two things he says. First, he doesn't know whether there's therefore some other unspecified, unknown representations. Secondly, he took, well, I haven't got it now specifically, he took me to a plea where you referred to representations. Oh yes, sorry, I do recall. He said in relation to the others, he didn't know whether that was including other ones that were set out earlier in the particulars or not.
Well, Your Honour, I am. I think that what we would say is that if facts are wrong, then they should be denied. If inferences are wrong, then they can be answered. And I do not think that taking in isolation particular words in a particulars of claim and saying that because these specific words are objectionable and insufficient, the court should therefore proceed to strike out the claim. But this is a broader point that does not bring us to the investment claim itself.
Well, for example, I'm trying to understand it. If you go to paragraph 6.18 of the particulars, you refer to, say, this is under the heading legal basis for the investment claim. 6.18 says the investment was procured through material misrepresentation made by the first defendant, including, and then are set out representations. And then Mr. Jackson says, because the word including is used, what you're then setting out is part of the set of misrepresentations you allege in 6.18. But do they include, for example, those set out at 6.14 or 6.9.2? Are those representations relied upon as part of the investment claims? That is, are they said to be representations made which induced the claimant to make the payments or enter the contracts or do what it is he did in reliance upon the representations?
Well, Your Honour, I think these are all, yes, these are all questions that I think can be dealt with through the ordinary procedure and not through a strikeout claim.
What do you mean by the ordinary procedure?
So we have given an answer to a request for further information. We have received no reply to that request for further information, but if it was insufficient, then we could have received correspondence in that regard.
I'm sorry, I'm confused. So you've made a request for further information.
The defendants, well, both parties have made requests for further information. The claimants have responded to the request for further information. The defendants have not responded to our request for further information.
What was your request for further information of what?
Our request for further information, it is included in the bundle. I will find the appropriate page.
Right.
This is, just give me one moment.
Yeah.
Page 278.
Thank you. Oh, that's a request for information of the second defendant's defence.
Yes, well, Your Honour,
but I'm concerned here with the request by the first and third defendants for information about the claim against them.
Correct, but we have received a request for information. We have responded to it, and there has been no further correspondence with regards to the subject matter of that request for further information.
Well, the response is the defendant says you haven't provided adequate particulars. That's why it brings this application.
And that is not in the spirit of the court's order. We're addressing the same point once again, but as the court said on the 10th of April, the proper procedural route would be focused Part 19 applications or case management conferences.
So in relation to the first and third defendants' request for information, where they've made a request for information and either received no substantive response or one that they don't consider to be adequate, is the correct procedure what, to go back and say, that's not good enough, give us another answer? Or are you saying what they should be doing is asking the court to now order that you provide a substantive answer?
Well, so, Your Honor, as the RDC makes it clear, there is no obligation to respond to a request for further information absent a court order, and yet the claimants have responded. What they now take objection to is the content of that response,
Yes.
without going for a Part 19.1 request to the court or engaging in further correspondence with the claimants.
I see.
So I think also read in isolation, RDC 416 does allow a party at any time to file a strikeout claim, but that is only when read in isolation. If the RDC is read in totality, I think we can say once again very clearly that this strikeout application is not the proper course. The proper course is, as the court has said, Part 19 or case management conferences.
Yes, all right.
But this exchange, this has brought me away from I would say, my script on this topic, and we were addressing the investment claims.
Yes.
And I think that what's key to say is that the primary facts that relied upon are not absent, and they include the first defendant's central role. He was the promoter and the controller of the venture. He circulated documents that regarded Fujitsu. He had other materials he made that asserted or represented that he had exclusivity, which was not the case. We have asserted the falsity.
Can I stop you there,
materials.
Mr. Gunson? Is the defendant entitled to be told what are those documents, or do you say you don't have to identify the documents for them?
Your Honor, the claimants have provided significant exhibits demonstrating the falsity of the representations. So just by way of example, the exhibits...
No, I was dealing, before I got to falsity, I was dealing with the representation. Mr. Jackson complains that in pleading the representation, you refer to, I think, 2 documents or some documents, but it's a non-exhaustive list. So I'm asking you, is it your submission that you don't have to tell them all of the documents you rely on? It's enough if you tell them some.
Well, that is correct, and let me expand further. In the first instance, there are a number of exhibits that demonstrate misrepresentation. That includes a slide presentation that is signed by the first defendant. That is in the particulars of claim attached as Exhibit C1A. That is not included in the bundle at the request of the defendant's solicitors. There is also an agreement between the first defendant and Fujitsu. That is attached as Exhibit C6D to the particulars of claim. Both of these documents are signed by the first defendant. They reflect the conflicting positions regarding the relevant representations. And I'm mindful that today, the task before us is not to conduct a mini trial or to delve into the merits. And I think one more important thing to say is that a representation is made, and if it is a misrepresentation, then the cause of action can be established. If there are 3 or 5 misrepresentations, then that is further strengthening to the case, but there may have been 30,
Mr. Gunson,
100.
If there might be 30 or 100, is the defendant entitled to be told what they are before trial, or is it something that they find out in the course of evidence, or what?
This will be materially expanded upon through evidence, correct?
So they're not entitled to know before putting on evidence what are the documents which constitute the misrepresentations. Is
Well,
that
Your
your
Honor,
submission?
as I said, these documents are attached to the particulars of claim.
Some of them, or do you say all of them?
Yes, these are some of them, and
Some of
further, yeah, and further will be expanded upon through evidence.
Well, that's, I think, one of the points Mr. Jackson makes is whether that is a course you're entitled to take. That is, or put it in the defendant's perspective, is the defendant entitled to know prior to going into evidence what are the documents which you say were documents in which the defendant misrepresented a fact or situation? Or do you say, no, you don't have to tell them in advance of evidence?
I think it's also important to refer to the RDC's requirements regarding particulars of claim.
Yes.
Particulars of claim are not expected to be exhaustive. They do not even have to cite law in its claim. So the particulars of claim are exactly what the court should expect in a course of this nature. And if the court determines, if the parties cannot agree, that further information is required, this can be done through what I believe would be minor directions.
Mr. Jackson draws attention to RDC 17.43, where what is required is first full and specific details of any allegation of fraud, dishonesty, malice or illegality, two, details of any misrepresentation, and so on. So he says that what you're required to do is to give details of any misrepresentation, not a sample of them, or to say some of them and there are others. He says you must give details of any misrepresentation that you rely upon. Is he wrong in that?
Well, many representations have been given. I mean, I was making my point previously about the number of representations that are wrong that are required to establish a misrepresentation claim. And one misrepresentation is enough to create the cause of action. If there are 3, 5, or more examples of that, then I think it is only evidence that reinforces the point.
With respect, Mr. Gunson, that's not what we're concerned with today. We're not concerned with what at trial will be sufficient to make out your case. We're concerned with, at the pleading stage, what the defendant is entitled to know is your case. Or put it from your point of view, what you're obliged to tell the defendant are the details of your case before coming to trial. Maybe that you can, I think we can all accept that if you allege 50 instances of misrepresentation and you make good one of them, you may win your case. But that's not what we're concerned with today. We're concerned with whether you have to tell them that all 50 misrepresentations which you are going to allege at trial. It's caricature in it, but that's
yes,
in a nutshell.
I mean, the claimants have pled that the representations were false. They were known to be false or made recklessly, and they're pleaded from the context from which that knowledge, or recklessness is to be inferred.
So what are the primary facts pleaded from which that is to be inferred?
The primary facts from which misrepresentation is to be inferred?
No, you said the falsity. You said the falsity is to be inferred. I'm asking you from what primary facts is it to be inferred? Sorry, not just falsity, his knowledge of falsity. You said that is to be inferred. I asked you from what primary facts pleaded is that to be inferred?
Well, if I now refer to if you talk about, if you look now at 6.9 of the particulars of claim.
Yes. Yes.
So, I mean, the first defendant, in seeking a personal investment from the second claimant, emphasized that his venture held exclusive commercial rights with Fujitsu. This was later shown to be false, as is shown in the exhibit.
So sorry, now take me to where in the particulars you plead that was false.
Your Honor, I've just read the particular line.
In soliciting a personal investment from the second defendant, the first defendant emphasized that the venture had exclusive commercial rights with Fujitsu, later shown to be false. Now, where is the particulars that he knew? What I was asking you about, following on from your earlier submission, was where are the primary facts which give rise to the inference that he knew it was false?
Well, Your Honor, this is the exhibit referred to here is the agreement itself. So that agreement is what the first defendant used to assert that he held exclusive commercial rights. When this contract was later revealed, it was shown that it does not give exclusive rights. So the first defendant had a contract that he had not disclosed. He used that contract to assert that he had exclusive rights, and that was later shown to be not the case.
Let's see.
So, Your Honor, the particulars of claim, speaking frankly, we provide significant evidence of misrepresentation and falsity. And I am mindful, once again, that we should not be delving into the merits of the case today. We are just speaking about the particulars of claim.
Mr. Johnson, you said that several times. Nobody has suggested that we should be.
Okay. Well, Your Honor, the IDC claims are a critical aspect of the claim, and to strike out at this stage would prevent, a very important issue from progressing to trial. Yes. And I would also say that, as is also set out, the investment claims do not stand or fall on deceits alone. They also address restitution, unjust enrichment, also promoter liability under DIFC corporate law. So an attack on just the dishonesty claim.
You'll have to explain to me promoter liability. I haven't understood that.
Well, before the second defendant was established, the first defendant carried on business as if the second defendant had been established or was operating. So under DIFC corporate law, it reflects a very common corporate position. If a promoter acts or purports to act on behalf of the company that is to be established, then he takes on that liability.
Yes.
So that is the reference to promoter
liability. Well, I think you're referring to the article in the company law, which says, in effect, it deals with contractual liability, whether the company after incorporation will be liable, or if it's not incorporated, then the person who purported to will be contractually liable. But those provisions don't provide anything beyond contractual liability.
Correct. Yes, that's correct.
All right. And that's what you meant when you referred to promotional liability, is it?
Well, what I'd like to emphasize is that misrepresentation is a claim under the law of tort. Yes. So we are requesting restitution under that, but not just that. There is also other legal theories for liability that include promoter liability as one among other reasons.
That's what I was asking you about. So there is some promoter liability other than the contractual provisions we were talking about.
We will be advancing that position, Your Honor. Correct.
In broad terms, what is it? What is this concept of promotional liability beyond when a promoter is contractually liable?
Your Honour, it is exactly that.
Well, that doesn't apply to a misrepresentation claim.
No, but the IDC claim, I mean, sorry, excuse me, this claim is indeed headlined the investment claims. So,
Right.
I mean, representation is one primary legal theory here, but that does not stand alone.
All right. Yes, please continue.
So I think I would like now to speak to the loan claim, which is the
Yes.
second of the three claims.
All right. Yes.
In this, the defendants say that Mr. Azzeh was not a party to the loan agreement, and therefore the claim against him fails because of lack of privity. They are attacking a case that the claimants do not bring.
So what is the case you bring?
So the claimants seek joint and several relief against the defendants in respect of the loss caused by the loan-related exposure. And that is not the same as alleging that each defendant is jointly liable as a contracting party under the loan agreement.
Well, what's the claim you have against the first defendant in respect of the loan agreement?
So, Your Honour, please can we turn to page 28 of the bundle?
28?
Yes.
Yes. Yes, I have that.
So the second claimant is seeking an order that the first, second, and third defendants be liable for this, for the loan claim.
Which paragraph? 13.
This is 13.6.
13.6. Yes, I have it.
So that being $262,000, which is the sum paid by the second claimant to the lender pursuant to a personal guarantee.
So that's the relief claim. And where do you plead the basis upon which the first defendant is jointly and severally liable for that?
So if you'll allow me to go through the particulars of claim.
Yes.
So if we go to now paragraphs 8.1.
Right. Yes, I have that.
So this sets out the broad factual background and also the legal basis by which the second claimant has a claim against all three of the defendants.
Well, just for the moment, focus on the first defendant. So
let us just speak again. This not being trial, let me just briefly outline what has happened. So a loan was given to the second defendant, which is set out here. A guarantee was given by the second claimant to secure the second defendant's obligations of that role. The first defendant was at all times aware of the loan arrangement and the personal guarantee. The first defendant was the controller at all times of the second defendant, as far as we are aware. And what is set out in 8.6 is broadly what has transpired. The second claimant has had to pay to the lender the entire principal amount and also the interest. That amounts to $305,000. Then there was, as set out thereafter, the lender and the second claimant entered into a deed of release and an assignment by which the lender released the second claimant. And with that, the second claimant now holds rights arising from the sums already paid to the lender and assignment rights. And so this is the sum of the amount of the loan claim. And in 9, it is our position that all of the first defendant was at all times in control of the second defendant. The second defendant is now, as they describe it itself, a defunct company. And it was his misrepresentations that caused the loan to be given. So that is the.
Are you saying that you're making a claim against the first defendant on the basis a claim in misrepresentation, that he made some misrepresentation which caused you to go into the loan and cause a loss? Because that's not pleaded, is it?
So, Your Honor, I mean, I can appreciate that there may be further detail or
well, it's not a matter of further
amendment.
detail. That's not pleaded at all, is it? The claim which is pleaded has nothing to do with misrepresentation by the, sorry, there's no plea of any sort that the first defendant is liable for misrepresentation in relation to the loan. The loan is pleaded purely in contractual and subrogation and assignment terms. There's no plea of misrepresentation in relation to the loan.
I suppose that is correct, Your Honor. In the particulars of claim, that is not what is set out. That is correct.
Well, you'd have to set it out to be able to maintain such a claim, wouldn't you?
Well, Your Honor, I would reflect that these two particular points could benefit from what I believe are minor clarifications to expand upon the reason for that claim. But I believe that the appropriate course would be a focused Part 19.1 proceeding, possibly. Well, that is what I believe is the most suitable remedy.
Requests for information can't cure a defect in a pleading. And where there's a pleading which pleads on one legal basis and you wish to maintain a claim on a different legal basis, you've got to amend the plea. You can't do it by way of request for information, because requests for information are to obtain more information about the existing legal basis pleaded. If you want to put forward a different legal basis, you've got to plead that.
Well, Your Honor, in that case, then, the appropriate course would be an amendment to particulars of claim, but not strikeout.
Well, perhaps I don't know what, when we refer to strikeout, I don't necessarily mean by that the claim is dismissed. Might be that existing claims are struck out with leave to replead it, which is, I think, is possibly the same thing as what you're saying, but I'm not sure. An amendment is an amendment to delete an existing claim and put in a new one. Whether you call that an amendment or a strikeout an amendment, it's all the same thing, isn't it?
Well, Your Honor, what I would say is that this claim is a complex commercial dispute that is broadly set out into three types of claims.
Yes.
The claimant's case is that the loan and the guarantee were part of the broader scheme, the commercial arrangement by which focused on the second defendant that was promoted, procured, and controlled by Mr. Azzeh, the first defendant. Mr. Gandhi, who's a claimant, he assumed exposure. Right. And that is something that the claimant should be allowed to bring to trial. And if it is not correct,
in relation to the loan, there's no plea that in some way he assumed liability, or I think your words were exposure. There's no plea that he assumed it in some way.
Well, Your Honor,
or material facts which would give rise to that.
The broader misrepresentations that are central to this case do ultimately address all of the three claims. They do not. They should not be seen as focusing only on the first investment claim. And in that regard, if the particulars of claim would benefit from an amendment, then that is something that can be considered, of course. But
Yes,
yes, that is how we would respond on this point.
yes, understood.
And I would like to, we are, I think, getting close to the time to schedule the trial, but I do have many more things to say.
Well, you've got the IDC claim. What else do you want to talk about?
Well, I had not completed my comment on the loan claim.
All right.
But
make such further submissions as you wish to make on the loan claim.
Okay. I mean, I will then, for the purposes of moving onwards, I will focus on what I think is the key point. The defendants repeatedly say that they cannot understand the case they have to meet. But at this stage, I think that what we're looking at is, if it requires tighter pleading, then that is a particulars point and is not a basis to strike the claim out. So I will now move on to the IDC claim. And on this point, I must state that the position is quite perplexing because it is focused entirely on the law of piercing the corporate veil. And so I would like to just, I will refer to my learned friend skeleton arguments. If we look at the case bundle, this is, allow me to find.
I've got a separate copy of it, so you can just take me to the paragraphs.
Okay, it is item 47.
Yeah.
So the opening line, if I would just read it, by the IDC claims, the claimants seek to hold IDC liable for all of the other claims advanced by the claimants against Mr. Azzeh and PCS under the doctrine of piercing the corporate veil. Well, Your Honor, that is a mischaracterization of the claim. So if you would now refer once again to the particulars of claim, this is paragraphs 10.8 to 10.10 of the particulars of claim. And I think that what is suitable is that I would just read this out so that it is very clear. So starting from 10.8, accordingly, the claimants plead in the alternative and as the evidence may establish that 1, the court should treat the third defendant as jointly and severally liable with the first and second defendants for the liabilities pleaded in these proceedings, insofar as those liabilities were deliberately evaded by the transfer, and that is the transfer of the second defendant's business to the third defendant. Further, or alternatively, the third defendant is liable to account to the claimants in restitution and or in just enrichment to the extent that it received the business, assets, or economic value of the second defendant without consideration. 3, further or alternatively, the first defendant is liable as a primary wrongdoer who procured or orchestrated the transfer, being, as we said before, a baseless transfer, and the third defendant is liable as a knowing participant or recipient, subject to proof at trial. 10.9, the claimants submit that absent such relief, the first defendant would be permitted to benefit from the claimant's services and investment, avoid payment of accrued liabilities, and continue the same business through a new corporate vehicle, which would be manifestly unjust. And in 10.10, for the avoidance of doubt, the claimants rely on the veil-piercing case only insofar as necessary and without prejudice to their primary contractual, tortious, and restitutionary claims against each defendant as pled elsewhere. So, given that statement, I do not understand how the argument on this point for strikeout focuses so much on the issue of piercing the corporate veil. I would go to say further that we do not agree with the characterization of DIFC law regarding piercing the corporate veil doctrine in the DIFC, but that is not a matter for today's case.
Well, it might be. It might be. perhaps we should deal with them in order, and so that you can come back to that. But you started with 10.8.1, which pleads the court should treat the third defendant as jointly and severally liable with the first and second defendants for liabilities pleaded in these proceedings, insofar as those liabilities were deliberately evaded by the transfer. What's the legal basis for that? Why should the court treat the third defendant as jointly and severally liable? On what legal basis?
So the second defendant being established in the DIFC was, for a period of time, the primary vehicle by which the first defendant was conducting business, or at least it became that at a point in time. Then, from the information that is available to us, the third defendant was established, and the business was transferred to the second defendant in a manner that resulted in the second defendant becoming, as the defendants say in their own response, a defunct company. So the first and third defendants have facilitated this transfer, which is to use one description, a fraudulent transfer.
But what cause of action does that give rise to? I mean, under insolvency law, that can have certain consequences. But if what you say, as most I've understood you to say, is that the first defendant, maybe the first and third defendant, caused the second defendant to transfer its assets and enterprise to the third defendant, and did so, I think you used the word fraudulently, by which I take you to mean they did so dishonestly in some way to evade liabilities. But that can certainly have consequences in insolvency. But what legal claim does it give rise to against the first and third against the third defendant?
Well, I mean, Your Honor, the first defendant, I would say this also, more information on that is in the defendant's hands. So we at this moment only have information.
But before we get there, we want to know what is your legal claim. What is the basis for your claim? Is it a claim in contract? Is it a claim in deceit? If so, what's the deceit? What is the claim?
Well, it's a claim that I think could be unjust enrichment. It could be misrepresentation. But when we have more information, then we would be able to further particularize this. But I would submit for your consideration, Your Honor, that the particulars of claim are broadly sufficient to set out what we are alleging in a complex commercial scheme, at which this time not all the information is available to the claimants.
I see. All right. Now, you wanted to also, you were about to tell me about the doctrine of piercing the corporate veil. You say that is a doctrine applied by, or a principle applicable in the DIFC courts. What's the basis of that argument?
Well, I don't think that I'm ready to go into this in detail at this hearing. So I do not believe that was the subject of today's hearing. But
well, it's part of you drew my attention to the fact that is the primary submission made by the defendant in relation to the IDC strikeout, and that's what you've come to meet.
Well, so if we are to address this, then I think that we need to begin with the common law. And I think that what we begin with the common law is that a company has its own separate legal existence, and therefore it is independently liable for its obligations. And what has been established over time is that there are certain limited situations by which the corporate veil may be pierced. And we would go back to case law of previous centuries to see how this doctrine has developed over time. And it could be in cases where a company is used to, if we refer just generally to, I think, English law and the common law, a company is used to conceal facts or ownership, if it's used to evade existing liability, if a company is undercapitalized or in other ways not operated properly. I mean, there are certain ways by which over time, English law and the common law then allowed veil piercing. So in the case of the DIFC, the DIFC has established its own company's law. It states the typical position that we would see across common law jurisdictions, which is that a company has a separate legal personality. And then there are, I believe, a few cases by which the courts have addressed this. And the way that my learned friend has characterized piercing the corporate veil under DIFC law is simply to say that it does not apply in the DIFC. So I believe it was a very brief characterization, but I think that is just simply not the case.
Well, he
took
me to Article 9 of the company's law.
Yes.
And recent case on that. Now, you say, well, no, notwithstanding that, so I think what you're saying is, notwithstanding that, the doctrine of piercing the corporate veil is part of DIFC law. So on what basis do you say that? Do you have some case authority for that? Do you have some principle for saying it? On what basis do you say that it goes Article 9 that of the company's law that Mr. Jackson referred me to does not deal with this situation?
Well, Your Honor, Article 9 is the very standard corporate law provision that we would expect to see in any common law jurisdiction, which is to state very simply the principle that a company has its own legal personality that is separate from its shareholders, and that its liabilities are not personal liabilities of its shareholders or directors. And I believe we would find a provision of that nature in every common law jurisdiction. And the DIFC, being its own independent jurisdiction, can refer to common law, case law from other jurisdictions, particularly England. And we have cases we can refer to in England that refer to this point. So that is the summary of my objection to the characterization that there is no judicial legislation making in the DIFC, and piercing the corporate veil does not apply.
Are you able to refer me to any case in the DIFC which has applied the doctrine?
Well, I believe that it's Veggie Bar versus Emirates NBD Properties. That is, if I'm correct, that is the...
Is that referred to in your outline, or if not, can you give me the citation? Tell me the case again.
Just have to... It is Court of Appeals case 13, 2016.
Yes, and what's the name again?
Veggie Bar LLC versus Emirates NBD Properties.
Sorry, Veggie Bar LLC v who?
The Emirates NBD Properties.
All right. Yes, okay.
And that is a case by which the Court of Appeals did say that separate corporate personality is deeply embedded, but I mean, this is a case that denied piercing the corporate veil, but I think it's just my pure point to say is that first of all, our claim on this point only addresses piercing the corporate veil in a tertiary manner, It is
I
really the
understood that.
last point that we rely upon.
I understand that.
And related to that, as almost a side note, I would say that the characterization that DIFC law does not recognize piercing the corporate veil is not a correct characterization. So that can be addressed in further detail, but that's my submission on this point at that time.
All right, thank you. All right, what other submissions do you have, Mr. Gunson?
So I would like to point out that these claims are not speculative, and the defendant's complaints are on certain words that, such as may, and as the evidence may establish, but these reflect the reality of the information of what the claimants have before them. And the particulars of claim under the RDC do not require for the claimants to set forth everything exhaustively. There are certain requirements of what we set out. We believe that they are certainly sufficient to set out the case, and anything further should be addressed through the proper manner of focused directions or minor amendments. So I think I will conclude my remarks by bringing together all of these points, which is that what the claimants see is a pattern of litigation tactics to delay this proceeding. And the court on the 10th of April set a timeline that to this date is not being followed because the jurisdiction application was submitted and then withdrawn. And today we do not ask the court to assess the strength of the claimant's case, but the points are far narrower, which is that the claims are legally recognizable, they are arguable, they are intelligible, and if it is to be disputed by the defendants, then that should be done at trial. And we do not believe the defendants should be allowed to avoid the ordinary progress of the action by recasting what I believe are very minor points, which at its highest should be for focus particulars or case management directions. So if the court considers that further clarifications are required, then the proportionate course is to proceed in that way. And so, Your Honor, unless I can assist further, those are my submissions.
No, thank you very much, Mr. Gunson. Mr. Jackson, in reply.
Thank you, Your Honour. I've got some short points by way of reply. My learned friend spent much time towards the outset of his submissions addressing what in my submission are peripheral points. It was said this application is the latest in a pattern of manoeuvres.
Look, I've heard the submissions, I've read them, I don't need to hear further about it.
That I wasn't going to trouble Your Honour on them in any event. It's just to say they're not accepted, but I'm going to get on to the substance.
All right.
If I can start then with the investment claims, it was said to Your Honour that the investment claims are not based on deceit alone, and that instead they're also based on restitution and promoter liability. Now, can I take those points in turn? Starting with restitution. The restitutionary part of the investment claims flows from the allegation of deceit. And that's the basis on which it's pleaded. So it's not pleaded as a standalone claim in restitution. And I can show Your Honour that at page 17 of the bundle.
Yes.
If Your Honour has that, it's paragraph 6.18.1 and the subparagraphs to that paragraph. So Your Honour will see that at subparagraph A, it said, it is an established principle of DIFC contract law that a contract induced by misrepresentation is voidable and gives rise gives rise to a right of restitution. Now, what certainly we understand that to be referring to is Article 40 of the contract law, which provides that a contract may be avoided and restitution sought where there is a fraudulent misrepresentation. So it's still the restitution that's being invoked is still premised upon fraudulent misrepresentations having been made. And one can see that's elaborated actually at subparagraph B, which refers to Article 40.
Yes.
And he just simply goes on to say it's also an actionable tort. And over the page, Your Honour can see it's 6.18.2. It's on that basis it said the second claimant is therefore entitled to restitution of all sums transferred. So I don't accept there's a separate case on unjust enrichment. It flows from the claim and deceit that's been pleaded. In terms of promoter liability, that is not a pleaded part of the investment claims. Where the claimant's allegation of promoter liability arises is in the context of their contractual claims against the first defendant and the second defendant. But as I made clear at the outset, and as is clear from the application itself, those contractual claims are not the subject of the strikeout application. And Your Honour, we can see that if we go to page 14 of the bundle.
Yes.
So Your Honour will see at paragraph 5.13, it talks about the first claimant's services agreement and the second claimant's services agreement constituting contracts for service. And so these are the contractual claims we're talking about. 5.14, it says no entity existed through the pre-establishment phase within which the claimants could have been employed. And there are other parts which deal with it as well, but in short, what we understand the claimants to say is on a contractual basis, because PCS was not yet formed, you, Mr. Azzeh, are liable in contract because you were promoting the company. But that doesn't form part of the strikeout application, so it's not something that should trouble Your Honour in dealing with the strikeout application. Now, my learned friend, the next point is that my learned friend submitted to you that the investment claims are properly particularised and that the primary facts upon which they're based are not absent. But in my submission, that it was very limited in terms of what my learned friend actually took you to by way of pleading. The only paragraph, I think, that dealt with the representations that he took you to was paragraph 6.9 at page 16. And what he hasn't shown you is where these representations are adequately pleaded, both in terms of the representations having been made, falsity and dishonesty. And that's simply because it isn't adequately pleaded. Now, what he then said was, well, the exhibits demonstrate the representations. And that, in my submission, is an unrealistic position. As my learned friend said, enclosed with the particulars of claim were 900 pages of documents. So, in effect, the claimant's position is, well, we should go through those 900 pages and work out for ourselves where the representations are alleged to be. That's, as I submitted in my opening submissions, just not how pleadings work. It was also stated by my learned friend in his submissions that if one of the representations is correct, they can succeed and the claimants are anticipating discovery. As Your Honour said, that's not really the question we're concerned with today. We're concerned with what my clients are entitled to know. But what that does illustrate as well in my submission is that this is a case of phishing, because the claimant's approach is to plead very non-exhaustive, broad allegations in the hope that they can get discovery later on the basis of those and then identify a case. and that's simply not the way things work in this jurisdiction. If I can move on then to the loan claim, my learned friend accepted it was correct that there was no plea of misrepresentation in relation to the loan and the guarantee. And in my submission, given that concession, the strikeout application should succeed on the loan claim, because the pleaded case can't succeed, and he accepted that there is no other pleaded case. Now, it was said that, well, this could be dealt with by way of a minor clarification. To be clear, in my submission, it wouldn't be a minor clarification. It's a new cause of action in misrepresentation that hasn't yet been pleaded. Now, if my learned friend wants to make an application for permission to amend and to bring that cause of action in, then he can, of course, do so. But at the moment, it's not part of the pleaded case. And in my submission, shouldn't prevent you from striking out the loan claim as it currently stands. Finally, can I deal with the IDC claims? It was suggested that the IDC claims were not focused only on piercing, and you were taken to part of the particulars of claim on that. If we could go back to that at page 26 of the bundle, please.
Yes.
Now, you were taken to paragraph 10.8, but it's important to read that in the context of what's just come before it. So 10.8, as per the heading, is talking about legal consequences pleaded. But if one looks up, it goes over the page, upper page to page 25, 10.7 is dealing with legal basis. So that's where we understand the claimants to set out the legal basis on which they bring the IDC claims. And it is quite clear that in that context, what's being talked about is piercing. So in the first sentence of 10.7, it's stated that the transfer constitutes an abuse of corporate personality for the purpose of evading the first and second defendants' existing obligations. That's at 10.7. 10.7.1 goes on to cite a small claims case in these courts, which talks about piercing. 10.7.2 again goes on to talk about the corporate veil being lifted. And then 10.7.4 again talks about the corporate veil being pierced. So that's certainly what we understand to be the legal basis. If one then looks at paragraph 10.8, 10.8.1, in my submission, is simply a point on piercing. If the allegation is that the court should treat the third defendant as jointly and severally liable with the other defendants for the liabilities pleaded, insofar as those liabilities were deliberately evaded. Well, that's the language of piercing, deliberately evading an existing liability. Then in relation to 10.8.2, again, my submission is that that is about piercing, because there is a claim in unjust enrichment made against the second defendant. And what appears to be being said is that the third defendant is liable to account to the claimants on the same cause of action. So it's mirroring the liability again. And 10.8.3, I acknowledge is a little less clear, but it's simply unparticularized. It's said that the first defendant is liable as a primary wrongdoer. Well, what's the wrong? It just hasn't been spelt out. And the third defendant is liable as a knowing participant or recipient. Well, if it's some form of accessory liability, you need to identify the primary wrong in the first place. So I maintain my submission that on any fair reading of the pleading, really the claimant's case is focused on piercing.
Yes.
Now, it was said that, well, the claim could be an unjust enrichment, it could be contract. It's not the claim that's been pleaded. There's no allegation in contract against IDC, there's no allegation in unjust enrichment. Again, my learned friend could make an application to amend to bring those in, but he hasn't yet. And that shouldn't trouble Your Honour for the purposes of this application. And the final point on the IDC claims is on authorities. And my learned friend said there are a few cases by which the court has addressed piercing. He referred you by name to one case, I think it was Veggie Bar and Emirates NDB. That's not referred to in my learned friend's skeleton, nor is it in the authorities bundle. So there's a real limit to how much I can make submissions on that case. The only other case I think that's in issue is the Jamaru case, which we just saw in the pleading. I've dealt with that in my skeleton. Essentially, it is.
Do you know the reference to it? It says it gives the number, but not the year of the case.
The Jamaru case.
Yes.
Yes, that's 2019. So that is in the bundle.
Oh, it is it? Okay.
Yes. Out of fairness to my learned friend, I referred to it in my skeleton because it is a case where piercing has been referred to. And perhaps I could just show you it briefly, Your Honour.
Yes, all right.
So it's page 959 of the bundle.
Yes.
So it's a case, as I say, in the small claims division. And Your Honour can see the claim is described at paragraph 13. So the claimant alleged that certain sums paid to the defendant for housing allowance in lieu of her employment, alleged that a sum had been paid for housing allowance and seeks reimbursement. The claimant was seeking various payments from the defendant. And essentially the defendant's response, part of the defendant's response was to say, well, this is actually my ex-husband who controls this claimant company that I was previously employed by. And Your Honour can see at paragraph 23, that's where piercing is referred to. It's on the next page.
Yes.
But what, at least as we interpret it, what that appears to be doing is repeating a submission that's made by one of the parties. So it's submitted before this court that the defendant's ex-husband is the owner of the claimant company. This court has the power to pierce the corporate veil, etc., etc. This is to prevent injustice. But actually, there's no application of, or no acceptance of that submission in the paragraphs which follow. If Your Honour looks at paragraphs 25 to 27, the claimant's claims are rejected on a different basis that doesn't relate to piercing. Yes, and in any event, Your Honour wouldn't be bound by this, but in any event, this decision predates the decision in Hamid. So insofar as they're inconsistent, I of course say Your Honour should follow Hamid. I'm instructed as well by my solicitors that the Veggie Bar case is 2018, so it also predates Hamid. So my submission is that is the appropriate case for you to follow. But more fundamentally, my learned friend didn't take you to a provision of the company's law or any other statute which allows for piercing. And in my submission, that is really the crux to this point. There has to be a provision, and none has been identified. Now, finally, if I can address Your Honour on the range of options that are available to you, I fully accept Your Honour has the power to order strikeout, or to direct further particulars or amendment, or dismiss the application. We, of course, say strikeout is appropriate. There are a number of points on that. First of all, amendment or further particulars couldn't cure the defects in the loan claim and the IDC claims, I say, because those are legally without foundation. Secondly, there hasn't been any application to amend that's been issued, and there are no draft amendments before this court. So if permission to amend were being granted at this stage, what would effectively be being granted to the claimants is some kind of open-ended ability to amend. It wouldn't, in other words, be a focused exercise. And that is, of course, the very reason why parties do bring draft amendments before the court, so the court can keep control over the process. And thirdly, there is no reason in my submission to think that if the court gave the claimants an opportunity to amend, that would remedy the defects. They have already had two opportunities by way of the particulars of claim and the RFI response. They are represented by a commercial firm of solicitors. they aren't litigants in person, and it would lack any utility in my submission to grant them a third bite at the cherry. Unless I can be of any further assistance, Your Honour, those are my points in reply.
No, thank you, Mr. Jackson. Well, I thank both of you and those who assist you.
Your Honour, if I may, I do have a few just final comments in response.
Well, it's not the usual process, but is there something which you feel you've not had an opportunity to address?
I do think that 6.20 of the particulars of claim, I have not had the chance to highlight that, and it did come up now in listening to my learned friend's comments, that a primary legal base of the claim is the DIFC law of damages and remedies. So I would just invite Your Honour to consider this also.
Look at 620, yes. Right. Yes.
Your Honour, not to make this a game of ping pong, but would you also
Yes.
look at point 20.3, which refers to the false statements again?
6.20.3.
Yes.
All right. All right. Well, thank you both for those further observations. And as I was saying, I thank both of you and those who have assisted you for your helpful submissions today. I will reserve my decision and I will let you have a decision as soon as I am able to. But thank you very much. That concludes today's hearing.
Thank you, Your Honour.
Thank you, Your Honour.